Hello, my dear aspirants. Let us take 10 more questions from our series to learn more about India's polity. Don't forget to catch the additional parallel learning through the images on the screen and also a bit of laugh with the cartoon here. All right, so let's take the first question. It says, where was the first civil services examination held in India? Now, if you saw the previous video, we have seen that the first examination for civil services was held in India in the year 1922 after the Government of India Act of the year 1919, which followed from the Montagu-Chelmsford reforms. And it was held first time in Allahabad. It was chosen as a decent place, a center of most of the provinces under the control of British, and also because Allahabad University was very popular, so most candidates, were in that area. And then later on, it was also held in Delhi. But yes, the first exam was held in Allahabad, and that picture here is the first training place for the ICS officers, the Haileybury College with its landmark turquoise dome. Actually, it was originally the East India College and later became the Haileybury College. And today it is the Haileybury and Imperial Service College. Next question. It says the Chief Justice of India recently has referred to which of the following parts of the Constitution as the woven rope that keeps the Constitution balanced. So it's just a few months ago to mark the 50 years of Keshavananda Bharati judgment. The Jindal University, OP Jindal University, had organized a reenactment of the 13 judges bench, where Chief Justice of India was also invited, and he just stated this as an idea that the Constitution is like a cart, or how the traditional woven cot in our society, mostly the northern parts of our country. And he said that when the Constitution is like a cart, the doctrine of basic structure is a weave of rope that keeps the Constitution balanced, resilient, and morally anchored. It is this intricate weave of principles that prevent the constitutional framework from collapsing under the political expediency. You may like to read more on this. Who knows, there may be a question. Then the next one says about the recent Supreme Court of India judgment with respect to menstrual health and hygiene as a fundamental right under which of the articles of the Constitution. Now, this is the case of Dr. Jaya Thakur versus the Government of India 2026, just earlier this year, March, April, where the court said that inaccessibility of menstrual hygiene management measures undermine the dignity of a girl child, and that the right to life under Article 21 of the Constitution includes the right to menstrual health. The court further added that the fundamental right to education under Article 21A and the Right to Education Act, which comprises free, compulsory, quality education, the court held that free education includes all kinds of charges or expenses that would prevent a child, especially a girl child, from pursuing and completing elementary education. And many of the girl children don't go to the school during and because of their menstrual cycles. So the court directed every school, whether government run or privately managed, in both urban and rural areas, to provide oxo biodegradable sanitary napkins. Then the substantive approach to equality under Article 14, that also demands that treatment be accorded with due regard to the individual, institutional, systemic, contextual barriers that impede the translation of rights in reality. So it is these three articles, 14, 21, and 21A, in the background of which the court has given this judgment. And since it is very recent and very progressive kind of idea, you may like to read more aspects of this judgment, and also from the science and tech perspective of what is oxo biodegradable sanitary napkins. Then the next question is regarding continuing mandamus, and it is saying which is the best description. See, continuing mandamus is a judicial remedy where a court issues ongoing and periodic orders to direct a public authority to fulfill its duties. That's what mandamus does anyway. But this is ongoing and periodic, while the court retains the jurisdiction over a case for an extended long period. See, the idea is it is used when a problem cannot be solved instantly. such as environmental issues, corruption cases, child rights. And the same has been issued in the case we just saw regarding menstrual health management. Court has issued continuing mandamus, where series of orders will be issued on a periodic basis, and the court will keep monitoring how much work is being done. So it's like an order to continue fulfilling their duties. It's not just one time you have to do it and it's over. So the correct answer here should be B, which says the judicial order that issues a direction through a mandamus but keeps the matter pending. This is the most important part. The first one could have been a confusing one for those who attempted it, that a judicial order that issues a series of directions through more than one writ of mandamus. So yes, there is more than one writ here also, but the point is it keeps the matter pending, and the directions that are issued, they are periodic. From time to time these orders will be issued, the court will keep monitoring that. So that's why the second option is more correct. The other two options are just to confuse unnecessarily, to catch people who are not reading properly. Anyway, so please be very clear because the performance wasn't very exciting. Then the next question is about the census of 2027. We all know census has already started in April this year. So this year and next year, this is a critical topic. You should have clarity. Statement 1 says it is an item under the concurrent list of subjects. Now, that kind of is an obvious idea that census is a national activity. So it is not in the concurrent list. It is, of course, in the union list. Specifically, item number 69 is in the union list. So first is not correct. Secondly, it says the Office of Registrar General and the Census Commissioner functions under the Ministry of Statistics and Program Implementation. This is very fundamental information. So just so that you know, I kept it here and changed it. It's actually Ministry of Home Affairs where it functions. Then the third one says every person of whom any question as per the Gazette is asked by the census officer, they shall be legally bound to answer such questions. Now this is correct. This is actually a provision under the Census Act of 1948. By the way, this is the act under which the census activity is undertaken. And then the fourth statement says the information collected from individuals is confidential and cannot be accessed by the courts. This is also correct. This is also a provision of the Census Act. And the idea is that no records of the census are admissible as an evidence in the court, unless, of course, it is a trial of an offense related to the Census Act itself. As a general rule, all the information is confidential, and it should be obvious to mind that it should be confidential as well. So third and fourth are the correct options here. And moving on, the Constitutional Amendment Bill can be introduced in the House of Parliament of India by how much support? Now, see here it is asking about introduction of the bill. It can be introduced. Now, why I kept it? Because recently all of you have seen the 131st Constitutional Amendment Bill with respect to increasing the seats of Lok Sabha and, women reservation and things like that. That got defeated in the Lok Sabha. And when it was introduced, then only it was visible that 185 members have voted against the introduction. So it was kind of clear that unless the government really negotiates and brings the opposition on their side, if the same kind of voting pattern continues, it is going to fail. And so it happened as well. So we should be also knowing, because not many people focus on this idea of introduction. We all know to pass what is the majority required. And that is why hardly 1/4 of the people got it right, because everybody thought it is the majority, total membership of the House and the majority of not less than 2/3. Now, this is required when the amendment bill is to be passed for the passage, not for the introduction. When the bill is introduced, there is a motion that is proposed by the member who is introducing the bill that I would like to introduce the amendment bill. And for that, voting happens. Now, that motion, right, which introduces a constitutional amendment bill, is passed by a simple majority. Okay, all motions in general, they'll be passed like this only. When the passage happens of the bill itself, at that time you need this special type of majority in option D. But for introduction, it is only the simple majority. So just be clear about that. And that's Madam Anna Chandy, the first female judge of India and also of the Commonwealth countries. Then next question, there are two statements given about the high courts. The high courts in India enjoy the power to review their own judgments. Then the high courts in India are considered courts of record. Now, in this context comes Article 215, which declares that high courts are the courts of record, which inherently gives them the authority to rectify their errors apparent on the face of records. They can rectify that. However, this review is not mentioned explicitly in the Constitution, unlike the Supreme Court, where it is written in Article 137 of the Constitution. For civil matters, in civil matters, the High Court is has got the power to review, and that is written under the Civil Procedure Code. Also, High Courts can only correct evident errors. It is not the power to reconsider. It is not the power to reconsider the case altogether fresh. It is review, not re-argue. Also, know well that the Supreme Court's review powers are more explicit and much wider, extending to constitutional matters, civil matters, criminal matters. They can even re argue and re examine the case with a bigger bench. High courts have no such possibility. There was a question in this regard in the 2021 prelims also. So do check that out as well. Anyway, for our question, the correct answer should be A. Both are correct. And the reason for the first statement is the second statement. So they have the power to review. However, it's very limited. It is not as wide as Supreme Court. And that comes from the idea of being courts of record. Okay. So that's that one. And the next question is about the statements with respect to the procedure for removal of a judge of Supreme Court of India. Now, since recently this was also in the news a lot, we should have our clarity. First statement says the Constitution of India specifies the grounds for removal as proved misbehavior or incapacity. Now, this is correct because under Article 124 it is stated. So, yes, it is stated in the Constitution. It is correct. Please see the Constitution yourself also. Second one says the motion for removal is to be signed by at least 100 members of the Lok Sabha or the Rajya Sabha. Now, this is not correct actually. This is the provision of the Judges Inquiry Act 1968. However, it is 100 for Lok Sabha, but not for Rajya Sabha, where it is actually only 50 members. So that is why this is wrong. Then the third statement says that if the motion is admitted, investigation is undertaken by a three-member committee consisting of a judge of Supreme Court, Chief Justice of High Court, and a distinguished jurist. Now, this is also correct, and it is a provision of the Judges Inquiry Act of 1968. So first and third are correct. And that picture is Justice V. Ramaswamy, the first judge of Supreme Court to face removal process. However, the motion to remove him failed in the Lok Sabha. Then it again is asking about some provisions of the Judges Inquiry Act. Which of these are correct? Now, first statement says only if the report of the committee undertaking investigation finds that the judge fulfills the grounds for removal, the motion is taken up for further consideration in Parliament and is voted upon. So, only when the committee finds that the grounds have been met, then Parliament can take it up. This is actually correct. Then, if the motion is adopted by each house of the Parliament, the address praying for the removal of the judge shall be presented to the President in the same session of Parliament in which the motion is adopted. That is also correct. So, both of these are provisions of the Judges Inquiry Act. So, if the inquiry committee finds that there is no evidence of proved misbehavior or incapacity, then Parliament will not take that motion further. Right? And when the Parliament passes it in the same session, President shall issue the order. So both of these are correct. And that picture is of Soumitra Sen, the first judge against whom the motion of removal was passed, but only in one house. That was Rajya Sabha. But before it could be voted in the Lok Sabha, he submitted his resignation. So actually, you all know that no judge of the Supreme Court or High Court has ever been removed from their office. There have been attempts 5 times. But they all end up resigning or the motion was never passed only. Now, the last question for this video, it says regarding the High Courts of India, how many of the following statements are correct? First one says all decisions of tribunals created under Article 323A and 323B are subject to scrutiny by a division bench of the concerned High Court. Now, this is an absolutely correct statement. This was also held by the Supreme Court. You all know in the L. Chandra Kumar case, L. Chandrakumar versus Union of India, 1997, and where the court said power of judicial review vested in the High Court is part of basic structure of the Constitution. And review shall be done by a division bench of the court. Division bench means two judges will be there, not a single judge bench. Statement 2 says the Constitution of India provides original jurisdiction also for the high courts apart from making them courts of appeal. So this is also correct. And a lot of people are confused many times, I find, regarding original jurisdiction of the High Court, whether it is provided or not. Now, the term original jurisdiction is not written. Like for Supreme Court, it is written, Article 131. But for High Courts, it is not written. But the way it is written, we know it is original jurisdiction. For example, Article 225, 226, they writ jurisdiction. Then 228, where it can transfer to itself any case which involves constitutional interpretations. From the lower court, High Court can take it on its own if there are constitutional interpretations. And also indirectly, this original jurisdiction is there in contempt cases because it has the power of court of record in Article 215. So its contempt cases are original cases, but that's more of an indirect idea because court of record itself gives this power indirectly. Though, unlike Supreme Court's certain original jurisdiction, this is not explicitly mentioned in the Constitution for the High Courts. Nevertheless, Constitution gives that original jurisdiction. Third statement, a judge of a high court holds office during the pleasure of the president, subject to the constitutional requirement for removal of the office, removal from the office. Now, this is absolutely wrong. There is no pleasure of the president there, and they hold office until the age of 62 years. So first and second are correct statements. And that picture is of the first Chief Justice of the Federal Court of India in 1937, Maurice Linford Guire. A lot of credit is also given to him for transforming the Delhi University when he was appointed as its vice chancellor in 1938. So that's all for this video. You study well and keep learning. Jai Hind.